Alrighty. Hello, everybody. We're just going to let people trickle in before we get started. Welcome to our webinar where you can ask Tom anything.
Anything at all. Just, it doesn't even have to be buying, selling law firms. It can just go off, anything. Who's going to win the Super Bowl this year? Of course, it's going to be my Lions in Detroit. They're finally going to get there. Whatever you guys want to ask, right? Well, I'm pretty vested into the World Cup though, right now, as Lauren, but overall, it's anything we want to talk about. So, thanks for everybody being here. Thanks for your support for the book as well. Excited to be with you. Absolutely. So. We'll get going, Lauren, as soon as you say go, and we've got everybody admitted in.
Alrighty. Oh, we have somebody who has a raised hand here. If you want to respond in the Q&A or in the chat, please feel free to do that. I don't see any messages. Oh, thank you so much, Brian. We appreciate the feedback. Cool. Alrighty. Well, let's get started. First, welcome everybody. Thank you for being here. My name's Lauren Mason. I'm Director of Marketing here at the Law Practice Exchange. And for the next hour, you have direct access to Tom Lenfestey. He is an attorney, CPA, and as you know, CEO and founder of the Law Practice Exchange. And he spent over a decade and has over $350 million in closed deal volume. And throughout over that decade, he's helped law firm owners sell, transition, and plan what comes next. And he just put all of that experience into a new book called The Exit Blueprint. I imagine most of you are pretty familiar with that. So just to give you a rundown on how today is going to work, this is an Ask Tom Anything, like he said. Anything is on the table here, whether it's about buying, selling a firm, transition, what comes after the sale, questions about writing a book, whatever it might be. Everything is on the table. So I see we already have one question in the chat here. So if you do have questions, please use the Q&A box. And we also are monitoring the chat. But if you do have a very specific question that you want Tom to answer, please put it in the Q&A and we'll be keeping an eye on that. So just to start the hour, I have one question of my own for Tom, specifically, why this book and why now?
Yeah, absolutely. Well, thanks, Lauren, for all your work in getting this set up. Thanks for everybody for joining. And yeah, it's great to have everybody and see the questions and everything else. And I think it was wonderful too to see all the questions come in even before, the program of everybody kind of submitting ahead of time. So I know we'll run through some of those, but please do ask your questions. As much as we can be a resource to you, whether you're in our sphere right now as a client or otherwise, we would love to help you and hopefully help move this marketplace in the right direction. And that's really why I wrote the book now, is I would truly tell you, even though I've been at this since 2013, so kind of a little bit of feeling like the OG to this really marketplace that's growing quickly and changing in a lot of ways. It felt like it had changed the most probably over the last 2 years. Private capital, private equity, and otherwise has a lot to do with it, but there's also just more buyers than ever before. We finally are starting to see some seller movement with lawyers planning for their exit. More and more questions, I think, about like how to do that. And so the goal of the book was really to try to say, if you can get ahead of it and plan your exit ahead of time, hopefully it's a good guidebook, right? Like you can start years ahead of time to plan your exit for when you're ready. Or if you're in a transaction now or you're really imminent to doing so, it's a reference, right? It truly can be a reference source where you hopefully can look and go through stuff to help you along the process. Just because I believe, especially for lawyers, we operate better when we have knowledge. We like to know kind of what our next step's going to be, right? We have trust issues sometimes. And so the overall goal is hopefully this reference, this resource that is the book allows you to do that. So really excited to bring it and kind of bring in things that we're seeing with, MSOs, private capital, but just buying, selling, exit planning in general. So for those of you that have read it, greatly appreciate it. Beach reading or otherwise, Brian, appreciate that. But the overall goal is hopefully it serves as a resource now and for years to come as things continue to change. Absolutely.
Amazing. And we have 6 questions already popping off in the chat. So thank you so much, everybody. Let's start with Harvey's question. He's a current LPE client with his valuation completed, and he's a C Corp with an internal candidate who's hopefully going to buy his practice. What are the best means by which to sell the practice to an internal candidate with a particular consideration for tax consequences? How can we best optimize that?
Yeah, absolutely. So thanks, Harvey. Thanks for joining. Everything else, as I'll kind of note, been at this for a while, definitely structured. I'm an attorney CPA, not your attorney or CPA. So I'll kind of disclaim it as good lawyer will disclaim anything. But if you're looking at that internal candidate, usually what we have seen is it will be an equity purchase, right? Meaning like if you're that C Corp, you will have that, internal candidate start to buy your equity out. Typically, that's going to be capital gains tax to you, right? So if you're selling equity of your C Corp, they're buying equity to that. That's going to be capital gains tax. And so for you, it's not ordinary income over the next few years that you would be receiving. It's capital gains tax treatment at a lower percentage, 20, 23, 25%. And that's usually what we would see as an equity. The good of that to you is it's clean, it's easy, there's not a lot of form, restructure or anything to the firm. The drawback is to your internal candidate potentially. One is you would have to indemnify of any kind of history of the firm, pop up of you forgot to pay taxes 2 years ago, those type of things. So, buyers are usually a little concerned with the past history. That usually structures over into what's probably the most typical we see in the market, which is an asset purchase. An asset purchase usually would have something where they're going to buy everything like the goodwill, the systems, everything that you can attach that has value, the reputation, the brand, right? And they're going to, roll that into a new entity that's going to acquire those assets. If most of it is goodwill, which most of law firm transactions are, it still can be capital gains treatments to you. You got to be looking at that C Corp and everything else from a double taxation standpoint. But overall, that transaction overall could be deducted by them, by the buy side, because they can actually depreciate the asset purchase that they do over a term, the goodwill assets that they acquire over a certain term. So they get a tax deduction for acquisition. You hopefully still get capital gains treatments. The C Corp aspect is tricky, right? If you're an S Corp or an LLC, that's a little tricky just based on your past retained earnings, other things that you may have. So, what I'd say is you definitely need to tag in your CPA to take a look at that. But usually, what we're going to see is equity otherwise. We'll also see when you've got some difficult tax structures, potentially a new partnership be formed, right? So a new partnership could be formed and you could sell your personal goodwill if you built up a big brand or otherwise around yourself. So you're not selling corporate assets, you're selling personal assets. That's a very deep conversation, but I'll kind of leave it there to say you've got some options, typically equity, sometimes, corporate asset sale, but there's this personal asset sale with C Corps that I'd look into strongly.
Yeah, super helpful answer. Thank you. Next, we have a question coming in from Robert about management fees. So he has 2 questions, but they're both kind of related. He wants to know, how should I set the management fee so it holds up as fair market value, but still leaves me a real margin? How do buyers build profit into that fee without it looking like a cut of the firm's revenue? And do you have recommendations for firms that conduct FMV analyses? And he also wants to benefit if the firm grows. So how can he build growth into that fee that's, per lawyer, usage-based, periodic resets without crossing the fee splitting line?
Sure. Okay, Robert. We're jumping in. So overall, what I'll say is for everybody else that just, listened or read along, this is what Robert's specifically talking about is our managed service organization or MSOs, right? That we're seeing now, whether it's, used for non-attorneys, private capital, or attorneys are using them too. And the overall structure is you have a managed support organization or a managed service organization that does the marketing, the HR, the accounting, right? Everything that's not law. And that is all housed in an MSO, right? The lawyers and the delivery of legal services are still in the law firm. But what that MSO does is it charges fees to the law firm for its services. So just like if I was going to go hire an outside marketing or outside accounting or anything else, they would charge a fee, and my law firm would pay that fee over. This is a related transaction a lot of times because you, as the MSO holder, may also own the law firm or have a vested interest in the law firm, but typically lawyers own the law firm, others can own the MSO. So when we get to that of structuring the services agreement, a little bit beyond what we do, because we'll typically tag in good advisors, but talking to people like Josh Port with Holland and Knight, right? Those different ones that are doing the complex MSOs right now. My understanding is they're all on fixed, rates or fixed plus. So there are different vehicles and different aspects that can kind of gradually come up, but it cannot just track with revenues because at that end of it, right, if it was just tracking with revenues on a percentage to say, oh, if revenues go up, so do our services, it would be sharing of legal fees and an ethical breach. So the overall structure is you really do have to go in there and value services at fair market value. I do not have a good recommendation for you today on doing that. We could get one for you. But the overall structure on that is really it has to be fair, like fair market value is the marketing fee that the MSO is charging to the law firm, fair and reasonable, just based on the marketing services that it's delivering. But remember, there's all these different things that are valued throughout it. So even in situations that we've closed and seen, there is still, fees and profit left in the law firm. The MSO just can't necessarily pull everything out. And that's okay, right? That's part of the overall structure that you want to look to. But the best way to do it is delineate really to go through what are those things that the MSO is going to provide to the law firm, look at fair market value of those services, which, as you mentioned, Robert, you have to get somebody to value those and look at doing it as a, fixed cost, like a monthly cost, or a cost plus based on certain variables or scale. And so when you do that, you are able to kind of framework, and it, of course, can be reviewed on an ongoing basis or kind of set. These agreements, just to let you know, are pretty complex as far as what the MSO attorneys are putting together. They are fairly complex because they are trying to assure that they are done ethically correct and that they are going to be approved by any challenge. If you're looking to do an MSO for your own law firm, like you just want an MSO and you're the lawyer that's going to own the MSO and you're also going to set up a law firm or you already have one, there's less risk, right? You own both vehicles, but you still want to go through that same exercise just to prep everything and make sure it's ready to go for as you go through for exit. So, Robert, I know I didn't answer probably your specific dollars or anything else. We can definitely get you a resource on valuing for fair market value. And I would heavily lean on if you're going to structure these to get really good counsel that are on the leading edge right now to do so, because it is an ethical, kind of area that's receiving a lot of attention. And so you want to make sure it's done right and it's going to stand up to any challenge you would do.
Perfect. Thank you. Very thorough answer. We have another really, really good question about kind of the emotional aspect of exiting from one of our anonymous attendees. And they say very aptly, how do you tell your team that you are selling without having them freak out? Which we get that question a lot, and it's a very good one.
I was just talking about this. Lauren, I was talking about our podcast guest from this morning, and I was talking about this is the belief of most attorneys that we've dealt with is if they let their team know that their team is going to freak out, right? And so we've had issues, of course, where, we're dealing with, 75, 80-year-old attorneys that they're worried about letting their team know that they're planning for succession or selling or exit. When really, if you want to break down in reality, what the team's really concerned about is what's going to happen when you do retire without a plan, right? Not selling the firm otherwise. So I would tell you there's a lot of times more fear from the team and your clients when you haven't communicated that you're working on a succession plan. And that's largely what I would tell you of kind of approaching it. You don't have to go tell your team today that I'm selling the firm, but you should look at key decision makers you're going to need or making sure you have team buy-in. And most of the time, the approach is you're looking to do this to make sure that the firm's going to continue, like the legacy of the work you've done, that your team has done, and that they would stay employed for years going forward, even if you were to slow down or exit or otherwise. So it's not a selling the firm and shutting down the firm. Most all buyers that we deal with, a key part of the deal is that your team will stay. Like they want your team to stay and they see that as tremendous asset for the firm. So I would tell you that the overall approach that we see is letting key decision makers know confidentially, right? Early and just having that discussion. It's not that you're throwing the keys and you're running out the door. Typically, you're going to be around after a sale for a period of time anyway, but also assuring them that when you do let the team members know that you're doing it with them in mind. And that's true, I think, right? You're doing it for clients, you're doing it for yourself, for your legacy, but you're also doing it for the team to make sure they can continue working, even if you want to be on the beach somewhere, right?
Yeah, absolutely. And definitely an important conversation to have, and definitely not one to wait till the last minute. So, definitely a helpful answer. We have another question here from Ron, and he wants to know what is the range of multiples based on gross revenue and net profits? Generally, would an internal sale to an existing partner lawyer multiple be higher or lower than an external sale?
Yep. So I'll give you the napkin math, right? We talk about it totally depends on the type of firm and the scale of the firm and how business structured the firm is right now. But typically we see law firms when we talk about adjusted net earnings, right? So like normalized net income, call it that, right? Like the bottom number that you get for being an owner. When we talk about that, it's usually somewhere between a 2 and a 3 multiple. And if you really want to break that down, probably most healthy firms land somewhere at like a 2.5 to a 3 multiple, hopefully, right? And deal terms and everything else are going to vary dramatically, but you're talking about if your firm makes $1 million and you're between a 2 and a 3 multiple, is it 2 million or is it 3 million? Right? Is really what you're asking. And I would focus on that net, benefit multiple versus the gross, because the gross multiple everybody uses one times gross. That's not true. We don't see law firms typically transact for one times gross, right? It's usually less because of the multiples that we're seeing and just the overall structure of law firms and deals. So what I would say is focus on that net somewhere around that 2.5 to 3 for healthy, good firms of a certain scale. Smaller firms, more personal to me firms are going to be a little bit lower. Larger firms, and especially what we're seeing, larger scale firms that have been built into better brands, business brands, everything else. A lot of what we're seeing in personal injury, family law, immigration, larger scale firms. We're starting to see it, of course, significantly break past the 3. And a lot of that has to do with private capital and other things, but those are definitely market exceptions one way or the other way. And then the other part of the question, Lauren, I'm sorry.
Let me go back and take a look here. Um, would an internal sale to an existing partner or lawyer multiple be higher or
Yeah.
lower than an external sale?
Yeah, it really depends. I would tell you typically the biggest fear about internal, right, is there should be a certain comfort if you've built a great practice or a good firm that they have comfort with it, especially if you've groomed them, shared financials, the management aspect and everything else. They should be a more ready buyer. They should be more comfortable about taking over everything else. The challenge you run into, depending on the structure and the timeline and the candidate and everything else, is sometimes they feel like they've earned some of that value or they've helped you like create some of that value, right? And so there's a lot of times the discount that they want for being a contributing factor to growing, part of this firm. So if you've got a $5 million firm but they've been with you for 10 years, there's a feeling of like, well, wait a minute, like my work, my efforts, everything else contributed to that. Why would I buy like the work? And you're going to say, but you were an employee and now I'm offering you ownership, right? I need you to put on the different shift of the hat and everything else. But usually there ends up being some kind of discount for an internal. So for that reason, we typically see external being a little bit higher. honestly, just because they're looking at the pure financial, trying to get comfortable with the model you built, and they're not expecting a discount based on tenure or the work that they've contributed.
Perfect. We have another chat from Brian, and we're going to shift gears a little bit and just talk about MSOs. And we've gotten a couple of questions in the chat about MSOs. So if you could give just a brief overview of, what they are, how it would be a good option for somebody, but also, some people who might have regrets, who, it might not be the right fit for them. What regrets could a seller have with an MSO transaction, but also, what are they? Who is a good fit for that? And any other insight that you have about that type of private equity transaction.
Sure, absolutely. So to start on a baseline, MSOs, managed service organization, or what hopefully we'll probably catch on eventually, LSOs. Let's go ahead and claim it for law and call it legal support, legal service organizations. They are all the non-law services moved over to a non-law firm entity, right? So they've really moved them over into an entity that's not a law firm, which means anybody can own them. It does not have to be a licensed attorney, anything else. It could be private equity. It could be, somebody else like a key employee, right? Otherwise that you want to kind of give ownership to. And that MSO can build its own value because a lot of times it buys like the brand. It buys the goodwill, right, from the law firm and kind of owns it over here. And so really it becomes the operating back office, you want to call it, but a driving force to the business side of the law firm. The legal services and the lawyers still sit in the law firm, right? That does not change. The MSO cannot interfere with those legal services as far as how they're delivered, the lawyers' choices, anything else. There has to be those independents. Where we're seeing MSOs used in really two avenues. One is lawyers just setting up MSOs for themselves to manage different brands. So if I'm a lawyer and I'm buying law firms, I can set up an MSO and really centralize my team and everything else, but manage this brand over here, right? Or locations or anything else from that side. Or I'm a lawyer, I need my MSO because my key employee who's been with me, who's my COO, CEO, whatever you want to call it, CMO, has been there, and you want to give them equity in something, you can't give them equity in the law firm, right? We had a situation where it was a father-son, and the son had really been managing the business of the law firm forever, but wasn't a lawyer. So in an MSO structure, he could actually take some ownership, not of the law firm, but really carry that forward. The other that we're seeing is, of course, private equity coming into this space or other individual investors, not always called private equity, family office, other private capital coming into this space using MSO as a way to invest in law firms, truly invest in law firms. So they can provide the marketing dollars, they can provide the tech dollars all through the MSO that the law firm can benefit from. And then there is a fee non-sharing, aspect, a services arrangement that really has the law firm pay the MSO for return of that investment, right? So if the law firm grows, so will the MSO, but it's because of that investment and scale. And private equity then can have an MSO that's centralized around a certain maybe practice area, call it personal injury, that puts best in class services is their goal, best in class C-suite knowledge makers, knowledge and decision makers in that MSO to really manage and grow law firms through that. So that's the vehicle that we're seeing private equity use the most to actually invest and partner with law firms in the structure and go. In the book, I talk about, like, hey, there can be regrets. Is private equity right for you? Right now, it's all the talk. MSOs, all the talk as far as private equity, private equity, private equity. What I would tell you is they are another buyer. They're just another buyer. So for you, law firm owner, if you're looking at exiting, you're looking at selling anything else, you have a new buyer to the game that you did not have before. But that does not have to be your only buyer. There's great still strategic law firms out there that are looking for acquisition, growth, everything else. There's great individual attorneys or groups of attorneys looking through that. There's our traditional as well. It really depends, and not every private equity is the same. So the overall goal and kind of our belief in, running the marketplace is that you should have options. Not all private equity, not all MSOs are going to be equal. You should really go through the dating process to figure out which one is the right fit. And if a private equity or an MSO is the right fit, or a lawyer, law firm, traditional buyer is a better fit. And so there can be regrets either way of who you end up with as your buyer. The overall message would be don't just take it that private equity's here, they've got money, they've got capital, and you're going to get the deal done with them. First, make sure they meet your goals, they meet the culture fit, they do have their MSO structure together, they're capitalized how you want them to be capitalized, they're going to do the deal and the growth plan how you believe you can do it, because it's all based on growth, and go forward from there. So hopefully that helps a little bit.
Perfect. Yeah, I think that addresses a lot of our questions on MSOs, but we'll definitely have a few more coming up later. We have another anonymous question. If a buyer wants a seller to stay on as an advisor after the sale, what are best practices for that, and what does it typically look like?
Yeah, and what I would say, every seller should stay on for some period of time after the sale, right? Well, I've talked about it a lot, hopefully in the book, in multiple places, and the message comes across. These are not laundromats. Everybody knows that. These are law firms. The lawyer, right, has value beyond just being the owner. And so we talk about it. It is truly a baton pass when you sell your firm. It is a transition post transaction that you're going to stay on for some period of time to just make sure everything goes well, right? You typically, most lawyers have personal relationships, whether those are referral relationships, industry relationships, right? Community connections, anything else, team connections that need to be transitioned. But the overall goal on that is to really have a purposeful plan. So, what I really try to encourage as we go through, we have what we call our transition plan resources. If we put a buyer and seller together and they've matched and they're moving forward and they do offer, great. They need to define what the seller's role is going to be post sale. So that's the first thing. Every letter of intent, every offer should really have what do you want the seller to do post sale? How long? How many hours? What are they going to be doing? Right? Try to start to framework it then. And then our best kind of recommendation is every week during due diligence and after, seller and buyer have that weekly, what I'll call just lunch meeting, which is essentially to say, what can we have seller do to affect this transition? To make sure they preserve what they built. This is their legacy after all. Preserve what they built and to pass the baton successfully to the law firm that's buying them, to whoever the next generation is, but to do that on a open communication plan because things are going to pop up. It's going to be a seller that 2 months after closing, they're going to say, hey, I got a call from this really good past referral source. How would you like me to handle this? Right? I haven't heard from them for 6 months or 9 months or 2 years, but how can we handle this? So open communication, but it truly is transition. It is not throw the keys, walk out the door. So I would tell you it's just ongoing communication and making the transition plan a key part of due diligence and after, not just the financials and the legal aspects of the transaction to do so.
Perfect. We have another question from Brian. He wants some advice on a specific scenario. He's working with another firm that's anticipating adding equity partners as an exit plan. And he wanted to know if you or someone on our team has ever facilitated the conversation with the team internally as they work through the concerns they might have as they consider the opportunity to buy into an equity position, or maybe help them find people to advise the incoming partners. And he's seen, if there's poor advising, it can definitely throw a wrench into the conversation. And when there's, maybe 4 to 5 people potentially incoming, they have to make sure that, someone isn't bringing weak advice. So any advice on that sort of scenario and pointers that you could give, Brian?
Yeah, I love it, Brian. I mean, I think it's a big part of it of bringing up the next generation. If you have those, right? And I know that's probably what you've been working on with them is, first looking and saying, who are those potentials that have this criteria of equity partner that we can move up, train, share, mentor, kind of transition so that there is an exit plan, right? So if that option is there, absolutely see it through. We deal with this all the time. Like part of our team just does internal succession and really works with, the next generation as these equity partners, call them buyers, because in one way they really are. They're buying into the firm, buying the ownership of the firm and everything else. But really with both sides, first developing that criteria, right? Like what are you really looking for? What does it mean to be an equity partner in this firm? What's the value that we would be looking to be exchanged? Like how do we perceive value of the firm? If you can get past those two components with the core group of current owners, and then you have a group, then it's really showing them the opportunity. Working with those tagged, I'll call it, or identified potential next equity partners to show them the value, to show them the opportunity, and hopefully to have them see it as truly the incentive of what it's intended to be, not a burden, but an incentive. And for some, the biggest thing I would tell you is some don't want it. Some aren't willing to take the risk to jump from, employee to ownership, and that's okay. And so usually there's also an aspect of going through to say, if they don't want it, what is their non-equity partnership, right? Hey, they've met all criteria. They're just not going to be an equity partner. So can we keep them and retain them, but in a non-equity, a salary partner role, something else from that side? Because you don't want to force it. You really want to offer it and have them be excited about it, ask all the questions and go through that. And we found that to be real successful, but it has to be, defined early by the current owners, and you have to just have the right candidates. And sometimes it looks on paper to be the right candidates for those next generation of equity partners, but they just don't have the entrepreneurship or otherwise to kind of take the equity risk. And so when that doesn't work out, you just have to say, that's okay. This won't work out, but there are other options that we can really preserve and look for the firm. Some of those may be external, but it at least lets you know if you have internal options first.
Great. We have another anonymous question. It's kind of a compound question. So first, what are the typical profit margins for smaller EP firms versus other practice areas? Number two, how would you increase leads and traction on potential sellers? And then also, from a buyer perspective, how do buyers typically approach the decision of, building a new firm from the ground up versus buying one that's already established? All great questions.
Yep. All right. So profit margins for EP firms, right? And other practice areas, how to really increase buyer opportunities, right? To look for that. And then potential buyers, how to really go through, do you build or buy, right? So let's start with profit margins. I think the all coveted thing is if you can be at 25% margins, you're healthy, right? So from a small firm or to a larger firm, anything else, 25. Do we have firms that are at 50%? Absolutely. Do we have firms that are at 10%? Absolutely. But the overall, somewhere between 20 and 30% puts you at a really good, healthy clip. Make sure that's true profit, meaning you're paying yourself as an owner for all the work you're doing in the firm. It's not disguised profit because you don't take a reasonable salary, but really to get somewhere between that 20 to 30%. It's not to say that a firm that's doing 10% is not a really healthy, marketable firm. Absolutely could be. But just as ranges, that's usually what we see, somewhere around there from that side. How do you increase leads for, traction for potential sellers, right? So we're looking for that of maybe looking at, how do you get more sellers? Well, first, big reason why we launched our marketplace a couple years ago was to give buyers more opportunities to match directly with sellers. It's a work in progress, always, right? We're trying to get word out there. We're constantly recruiting, doing crazy things like this or writing books or anything else to bring in more of those sellers to get them to take the first step. But the overarching aspect is we tell everybody, what we do in our marketplace does not have to be everything. I would tell you great resources if you're looking to buy law firms, like you're looking for more sellers, is to contact your lawyer and insurance companies. Like here in North Carolina, a great trusted resource for us is North Carolina Lawyers Mutual. They have lots of solo and small law firms, and they get calls maybe weekly, not every day, but they get calls from attorneys looking to retire, get resources on how to retire, and they could potentially say, well, look, in your market is, I think, somebody that would be interested in talking to you. Same thing with the state bar, bar associations, and getting involved in those groups and leaderships. And then it never hurts to reach out directly under the aspect of, hey, I've always, been an admirer of your firm, what you built. I wonder if, there's an opportunity for us to talk about us being part of your succession plan, and kind of go from there. And then the third piece, Lauren, I already forgot it. Was that it? Third?
There was one more from a buyer perspective. If you're a buyer, how do they
Buy
typically
versus
approach,
build.
yeah,
Yeah.
buying versus building?
Yeah, and so it's a real trick with our sellers too. There's always an aspect that you have to give buyers enough incentive that it makes it worth it to take on the risk of buying versus them just building their own firm in your market, right? So many of our buyers are looking for geographic expansion. And so if you're in Virginia and we've got a firm in, North Carolina or otherwise that's looking to go in Virginia, they may look to your firm to acquire because it gives an immediate, geographic location, immediate revenues. But if they're a pretty proven operator and they've got good marketing, they've got good systems, everything else, they could just start in Virginia. And so you have to make sure that when you're looking at that aspect is as a seller, you can't be too greedy. You've got to leave enough incentive for a buyer to buy, take on those risk of, acquisition, and hopefully making enough incentive that it makes it better than them going out and doing it themselves, basically building their own Virginia location, law firm, anything else. And if you're a buyer in that, it's the same exact thing. It's really to go through and evaluate, look, acquisition is great. And it hopefully, if it's a $2 million, $5 million, $100 million opportunity, right, there's always an aspect to say, how long would it take me to get here? And what's that cost to do so? And really, where I get to is, if the terms aren't there or otherwise, go back to your strengths, built basically, right? Look at that buy strategy. If the opportunity and the terms and the fit are there with that potential seller. But if you're a good builder, meaning you've got a good firm, scalable and everything else, definitely look to that. But there is a certain point where if you can take $5 million of revenue that's already there and built, put it onto your platform under a good transition plan, under a good transaction structure, it can be wildly successful because probably you as a good builder are going to take that 5 million and, over time or very quickly sometimes double it, triple it, quadruple it. And that's really the opportunity instead of starting from zero.
Great. We have another question from a private equity investor in the Q&A box. They are part of a PE shop looking into the legal sector. So what types of firms are we seeing really being targeted in this space? Is it just personal injury or general business services firms? What are the practice areas that are really seeing a lot of traction for private equity?
It's amazing. Probably 2.5 years ago was the first time I did a podcast for middle market growth. And after that podcast, there was all these calls from private equity exploring. And then once they explored, really it's drawn into personal injury, is kind of where we're seeing most of the market movement. But the reason for that, I think, has largely been because those were the first moves by private equity to invest knowledge, research, everything else into personal injury and get comfortable with the business model. Essentially, very strong marketing, like business marketing, not attorney marketing, less dependent on the owner, right? Less dependent on the attorneys. So if an attorney left or anything else, half of your revenues don't leave with them. And they built better systems overall than some of the other practice areas, right? Because PI spent lots on marketing. So then they spent money on intake, then they spent money on software, right? And so PIs kind of led in certain ways from that side. But what we've seen in the last year, year and a half is kind of the catch up. So now we see a lot of private capital looking at other areas, because personal injury is moving so fast, right? And the multiples are moving pretty quickly in personal injury, significantly quickly for certain types of firms, and everybody's kind of chasing that area. So we're seeing immigration, we're seeing family law, we're seeing trust and estates, we're seeing insurance defense interest, we're seeing, interest across consumer and across corporate. I think the two biggest things that are missing right now for private equity to make significant movement in some of these other practice areas are one, that same knowledge, education, and research to put together really good MSOs. So if you want to think about it like the best in class MSO for family law. If a private equity group were able to take, that and put together the best software, the best tech, the best marketing, everything else to put that knowledge, that's a tremendous pitch to a good family law operator, right? To do a deal and kind of partner with private equity in this because they can invest and help grow, right? And so that's what we've seen in personal injury. Now we're waiting to see it in other practices. The other challenge is private equity a lot of times is they have a what we'll call an EBITDA, right? Earnings before interest, taxes, depreciation, amortization, really your adjusted net, right? Your bottom net number. But the overall is we've seen that be they want 10 million in EBITDA, right? So it takes a certain size firm and to really get there. And so the only firms that have met that thus far have been personal injury. There's less family law firms out there that are doing 10 million net and owned by one or two people. There are some. There are less trust and estates firms that are out there doing that. There's less immigration. There are some. And so we've seen kind of this, mismatch on cap on earnings as well. But I think what we're going to start to see is the smaller private capital in the space, the smaller MSOs are really starting to acquire or invest in some of those platforms and are going to band those together and then they'll become part of the larger PE. So what I would say is personal injury, definitely. But we're seeing other plaintiff areas like Social Security disability, workers' comp, right? Anything else. But we're also seeing moves, significant moves in immigration, family law, and otherwise, just depending on scale that you're looking for.
All right, perfect. We have three more questions from our attendees, so I'm going to make sure we fit all of those in and maybe one or two of our pre-submitted questions. So first, we have somebody asking about Social Security practices. We've sold a few, but they want to know if there's anything unique about selling this type of practice.
Yeah, well, I think Social Security is, again, similar to personal injury in a certain way, right? Like you have future inventory otherwise on the shelf. The interesting part about Social Security, of course, is this as Social Security practitioners, but you already have non-attorneys in the space as what they call advocates. So it's kind of an area where you have law firms and non-law firms, playing. I would say law firms have the advantage because they can go through the court systems and really try to maximize those Social Security benefits for their claimants. But at the end of the day, when you look at it, right, you are dealing with similar aspect. How well is the machine built on brand, right? How unique is the brand? How defined is that as far as the intake from that brand, like the marketing leads to the intake? And then do you have good systems and operations and the data to back it up? We've seen a lot of more smaller Social Security practices. So the goal is how many of those could be built up to be larger practices, less return than those personal injury counterparts, as you know, but it can be a great practice to deal in quantity. It can be a great practice to really band together and do more at scale and do really good work, have the best attorneys that can really navigate, have the best systems to make sure you can navigate the different vehicles. Similar to personal injury, though, you do have inventory. So that is future revenue on, in the firm already, right, to be claimed. So you are working for free, just like workers' comp and some of the other areas as well. You're working for free until it's resolved and you receive payment, and that's usually an asset. So the biggest thing with those type of practices, or if there are future revenue or anything else, is to really look at it as an asset when you price it and when you were to do a transaction. So we like Social Security practices a lot. There needs to be more, I would say, strategic, good buyers in the space that'll catch up to like personal injury. But overall, you've got a great practice. It's going to be looked though, is it personal referrals? Is it community based? Or have you built really that brand? Because they're going to want to look more like the personal injury brand exercises as you go forward.
Fantastic. Now we're going to switch to a different practice area. We have a question about criminal firms. And this person asks, what are the multiples like for a criminal attorney firm? Most business is flat fee, not contingency. Typically, there is not a lot of repeat business like business or family law.
Yeah, typically. Although I used to say that to our family law people too, and they'd say, like in criminal and family law, there is that repeat. What I would say is multiples can vary, widely, right? When we're talking about if we're going to earnings again, we can be at like a one multiple on a low criminal practice because it's just me and it's just my reputation, right? And everybody in the community knows me. The first practice I ever transacted was a criminal family law practice in a small town. Very low multiple, done as a transition, kind of creating a partnership with a young attorney that was coming back to hometown to do that. But overall, it was a very low multiple because the brand was the attorney. The other thing you have to realize on a flat fee, if you are charging, let's say $500, $1,000, $5,000, right? And you charge that up front, when you go to sell, there's a certain amount of work remaining to be done. So those fixed fees that you've collected in advance actually become a liability at sale. And so that's something you have to look at is, overall, any fixed fee practice. We see this in immigration as well. There is, work in progress, but you've already been paid for it. Counter that with like our personal injury, Social Security, who have not been paid. They're working for that fee in the future. And so it becomes a little bit of you have to do a calculation at closing for how much have you already received needs to be credited potentially back to the buyer to complete that work so that they don't just, take over and they're paying for the team or anything else to complete a bunch of cases that you've already received the fees for. So there is a calculation there. It really goes down to how much of a brand, a business brand you've built, how much of that is a system, right, to really carry that forward, compared to how much is dependent on you and how much is dependent on maybe your attorneys within the firm. If it's all dependent on you, your reputation, the judges, the community, they only refer to you, your value is going to be lower. You can extract more value by finding the right, I'll call it fit partner, right? To kind of come in and it's going to be more performance based. It's not a cash at close deal. It's going to be more like, hey, if you can help us transition and still be the figurehead in the community, everything else, and we retain these referrals, we can still make that as part of the buyout. But overall, it really goes to what type of criminal defense practice you are. But remember that aspect on flat fee. That's a great aspect just to bring up across any practice that charges fixed fees. We've had that pop up a lot. There's just a calculation that needs to be done on that part.
Perfect. All right. Before we move on to the next question, I'm going to say last call for questions. If anybody has any more, please put them in the Q&A box. If we cannot get to them, we will make sure Tom gets you an answer when we send out our recap after our webinar. So last call on those. If you have any more, please put them in the box. But now we're going to probably end with some private equity focused questions since that is quite the hot topic. So this anonymous question asks, how about long-term incentives for sellers? What are you seeing in terms of long-term incentives to ensure value creation is aligned? Obviously, paying value up front, but making sure the seller stays around to support the ongoing value.
Yep. I would say every one of our deals that we have in a law firm, and we've had some deals that are 100% cash at close, but most have some kind of what I'll call balancing of risk because most law firms still have dependency on the seller, the owner, whether it's their reputation, right? Whether it's their daily work, whether it's their referral sources, whether it's how they interact with the team to keep the team happy. You as the seller usually have some value, right? That's at risk of transfer to another. And so the way that that's structured is there's a performance metric, meaning I'll give you exit closing cash, right? We close, but then this rest is paid out based on performance. The two components that we've probably seen the most is, under the private equity deals and the MSOs, we're seeing that as true equity, right? There is an equity retained in the MSO. So if I sell and I am going to retain 20, 30% of my value, potentially that is my purchase price, but it's rolled over to the MSO, which is hopefully going to continue to grow in value as it acquires other law firm brands and everything else. And so there's that equity tie, right, to that. The other most common is just truly performance. how does the law firm really, preserve what it's built based on revenues, based on other things, and kind of hopefully grow that. And the easiest one is, what's called, an earnout or anything else, but it's a percentage of revenues. So it's like if the firm's doing $1 million in revenues and we give 10% of that as a purchase price, that's 100,000. Great. Everybody agrees to that. Year one after closing, it's 100 or it's $1 million revenue still. Great. 100,000. Year two after closing, it's 900,000 in revenue. Something happened. We lost some clients, anything else. Well, now the seller is getting 90,000, right? So the goal on those performance metrics is really it's an assumption or a balancing of risk between the seller's brand that I built personally, that there's fear of will it transfer to the buyer, right? It's just this personal aspect that we've built. If you built a total 100% business that you have nothing to do with, you're going to get more cash at close. If you built a law firm that is very dependent on your personal brand and you generating revenue, originating clients, keeping things moving, there's going to be more performance that's going to be requested because a buyer sees risk. And so overall, the other component that we see when there's bank funding involved, especially SBA, is a variable seller note. And so it would be something of like, again, $1 million deal. You pay 500,000 cash at closing, and then there's a $500,000 variable note that could come into play that could adjust based on revenue performance, right? So we've agreed it's 500, but if revenues drop significantly from, 1 million down to 700, the note payments also drop. The other last thing I'll kind of mention on this is SBA can also do an escrow structure. So you could agree on 500, cash at close plus 500 to be released, but it is going to be about around performance as well, or certain metrics like employee retention, right? Other things that you really want seller to help with. And then you can release those escrow payments as those milestones are hit. So I'd say equity, definitely earn out or revenue performance metrics, seller notes that it can be variable, and escrow as that kind of final piece.
Amazing. Now we're going to move to just a few of our pre-sent questions. First, this is from a prospective buyer, and they want to know what makes a seller pick one buyer over another? Is it price, the equity upside, cultural fit, certainty that the deal closes? What really tips a deal?
Yeah, I'm going to say, price matters. You got to be in the range, but we've typically seen more sellers over and over choose based on fit over price. And that's, I mean, you can probably guess for so many of our sellers or those that are on this call right now, is the overall aspect, it's your legacy. You know how your firm runs. And when you find a buyer that essentially you find that good fit, you see what their potential vision is, everything else, and you see how it could really work for your firm. You're more comfortable to do that deal than somebody that just comes in and says, I'll pay you more or I'll give you more cash at close. And we've had those again where we've had sellers that say, I want this much cash at close, I want this. And when we bring it, but then you have another buyer that offers maybe less, but there's more fit, they choose the other, right? I would say, by and large, law firm owners that are looking to exit, looking to sell, anything else, choose fit over financials. What you can do as a buyer to really try to differentiate yourself is come in with a plan. And I mean, yes, you're going to have a financial plan for how you're going to pay them, how you're going to structure this, everything else. But really, it's what would be the plan to preserve the legacy? Like, give that some thought, right? Put together a framework for how you're going to transition the seller, how you would really preserve the legacy, how you could really handle this post closing, because that's really where the sellers get hung up on the unknown of how it would really work, or they start going through worst case scenarios. We're attorneys, that's what we do. And so once you go through those worst case scenarios, the buyers that can come with this is the plan, this is how we're going to invest, this is how we're going to nurture, this is how we're going to preserve. And seller, this is what we'd ask you to do if you're comfortable with it, to help us do that. They're going to be wildly more successful. So instead of just submitting a term sheet and LOI, really giving them more of kind of like, here's our business plan if we acquire your firm, means 10 times more to some of these sellers than actually the financial price.
Great. And I'm going to ask one more. This is probably a 201 level question, but I think a really good one to close with. Also from the buyer perspective. There's a lot of changing regulations with MSOs. So let's say there is a private equity company that, buys a law firm through an MSO. They're curious to know in that sort of situation, what level of involvement, is the real ceiling here before regulators or a bar might try to challenge this. Can they be involved in pricing, intake, hiring, marketing? What is the limit with an MSO and what is the typical balance that you see with, the actual lawyers who still own part of the firm versus the MSO that has a stake?
Yeah, I'm going to give credit to my buddy Josh Port over at Holland and Knight, who really said the role of the MSO, truly by definition, is to support the lawyers. And if you forget that as an MSO, like you're telling the lawyers essentially, what to do or otherwise, you have really gone contrary to what the whole intent and purpose of a, managed service or support organization should be. And so to answer that question, Lauren, is you can't tell the lawyers how to practice law, right? At the bare minimum, you can't tell them how to take clients, what clients to take, other aspect from that side. You really can't do that. Can you build systems like other law firms have built to help filter, to help, market to bring in the ideal clients for the firm? Sure. Can you help train good intake and everything else so that they know? Absolutely. But you can't impinge on those lawyers providing the legal services. And I just think, like, when I give credit to Josh on that comment, is because I do think that's the core. Like, you have to realize that the law firm has to be independent, and lawyers are rogue, right? And the overall working relationship's not going to go well between MSO and lawyers in the law firm if you're really trying to tell them what to do. And there's been good examples already, I think, in the market of those deals that have been completed over the last couple of years and having some differences, right? Like the lawyers have a difference of opinion with like the MSOs, and how it's just really been more of it is like a discussion of how to really bridge the business with the legal, not to tell what to do, but to really respect we have to do it this way because this is how the law firm needs to do it. How can we modify? How can we accommodate for that MSO, but not to break those barriers? So there is walls. And I think the biggest thing is to remember that the MSO is truly there to serve the law firm. And a big thing with law firms is, with lack of non-competes, and for a lot of law firms, a lack of employment agreements, if the MSO doesn't really do that role of supporting and really wants to go in and create conflict, change everything overnight, really force these lawyers to do what they need to do, you're going to lose lawyers. And, law is still a very human capital intense business. And so from an MSO side, it's really to go in. And I think the good ones thus far have really gone in with the best intentions to serve, to help, right? Increase, improve technology, improve client care, right? Improve marketing, improve HR, all these other things, but also to let the lawyers practice law and not step on those. And I think you'll have a good marriage.
Perfect. Well, I know we're getting really close on time. So before we ask our final question, I just want to thank everybody for coming. You had super insightful questions. So thank you for taking advantage of this time with Tom in the best possible way. And one last plug, if you have any questions, you can reach out to us at info@thelawpracticeexchange.com and we will get back to you as soon as we can. And we have one final question from YS that Tom, I'm pretty sure you'll know the answer to this one. They were curious about how they can get support for their firm, through evaluation, through getting MSO advisor support, and that kind of sounds like something we might be familiar with. So if you can give them maybe a recommendation and then any closing thoughts as we round out our webinar.
Yeah, we'd be happy to help, right? So for the Law Practice Exchange, we have our two components. We have our marketplace and our team of advisors that serve our marketplace. And then we have our private market, which heavily deals in, private capital transactions, MSOs on this side. So whether it's just a helpful phone call to point you in the right direction, truly, right? Or if we can help you, based on your goals or your process or, transactional needs, happy to do that as well. we have great trusted partners in this space. So we're happy to connect you with those and make sure we can really, again, grow this market in the right way. And I think it all starts with stuff like this. So absolutely, we can help you at the Law Practice Exchange. Feel free. Message us, email us back from some of the invites you've received on this, and we'll take good care of you to do that. Or we'll get you aligned with the right partner to do so if it's not something we can help with. Absolutely.
Perfect. Well, we have reached our hour-long slot. So thank you so much, Tom, for answering all these rapid fire questions. We appreciate it. And like Tom said, if you guys have any further questions, want to take the next step, please reach out to us, and we are always here to help. And please be on a look or on the lookout in your inbox for a replay of the webinar and a free digital copy of the exit blueprint. So thank you everybody so much for coming, and we look forward to seeing you or hearing from you again soon.
Absolutely. Thanks, Lauren. And thanks everybody for joining for the read on the book and just, being part of this learning process as we, what I tell everybody, grow this marketplace from the pond that it's been, hopefully into a lake, and then kind of move it from there, which hopefully is good options for everybody, whether you're looking to sell, buy, invest, anything from that side. So thanks for all the help in putting it together, Lauren, and everybody else. Thanks for your time.
Thanks, everyone. Bye.